valuable and safeguarding them through the right agreements can make all the difference. So to guide us on this important subject, please join me in welcoming Mr. Saurabh Sharma, Managing Director at JSW, as he speaks on the role of agreements in sales IPR. Over to you, Mr. Saurabh.
In English, okay with everyone, या हिंदी में बात करें? No, I'm English with both. All right. So we'll continue in English. First of all, I would like to congratulate each one of you that you have made some time on a Saturday morning, coming here, taking out time for yourself. You have come here not for attending the event, because you see an improvement in yourself. You believe in yourself, you want something to be added to your personality, your skills. That is why you are here. So you must give a round of applause to yourself. Further, talking on the topic of IPR and business agreements, are there any law students here? Okay. And are there any management students? Alright. So, can you tell about what's intellectual property?
I'm expertise in IPR.
Okay.
My expertise are.
So you are a law student or a lawyer?
I'm a lawyer.
Okay.
Yeah.
Alright.
And I'm expertise in patents.
Okay.
And I represent a firm that uses patent, trademark, copyright, everything. But my expertise is in patents.
That is.
That's why I am.
That is very good. I am asking, what is intellectual property?
So,
if you could share with our audience.
Yeah. So, intellectual property right is basically the ownership of your idea legally that you can own and license in the market.
What's your name?
Saurabh Sharma.
Sarojji, you are giving a very insightful information. But I come back to my question, what is intellectual property? My friends,
this is for टच नहीं कर सकते वो इंटेलेक्चुअल होती है इधर इन केस
वो उसका ट्रेट है, वो उसका फीचर है. आई एम आस्किंग व्हाट इज इंटेलेक्चुअल प्रॉपर्टी. बड़ी सरल भाषा में मैं समझाता हूँ. इंटेलेक्ट इज अ थॉट. It is the property of the person who has thought about it, who has given it a thought. There is a peculiar feature to it. It is innovative. It is novel in its structure, in its formation, in its foundation. Suppose you run a sweet shop by the name of X Sweet Shop. You are very popular in Delhi. A person from Sonipat, he approaches you. Sir, I want to open a franchisee of your shop, of your sweet shop. You get elated with joy. Alright, I'll have double the business, I'll have double the profit. On top of it, all the hard work will be done by this guy from Sonipat or Palwal or Rohtak or any other place. But when you draft an agreement of franchisee with that person, then what do you have to take care of? You have to take care of all the rights of your patented trademark that you are willing to share with the person. Because if you ask him, if you give him all the rights to use the name X Sweets, he might as well start a chain of namkeen by the name if the agreement is ambiguous about it. He might start a chain of fast food restaurants by the same name if your agreement is ambiguous about it. So people think that intellectual property rights and intellectual property law is required to be learned, or it comes into play only when there is a dispute. No. You need legal help from the very inception of the agreement. The agreement has to be so watertight that there is no scope of ambiguity at all. There has to be meeting of minds. Both the parties, you and the person with whom you are having an agreement, should be on the same page. Both have to have the same idea while drafting the agreement. You should know what is the aim, what is the scope, what is the dispute resolution process, what is the ultimate aim of drafting that agreement. You have to see if at all there is a dispute tomorrow, whether you want to opt for litigation, whether you want a third party to be a mediator, or are you comfortable in the arbitration proceedings? You have to see to it. So all that has to be done through a lawyer. There has to be no ambiguity. That is the prime concern. Now, what is the concept of novelty? How do you say that my product, my trademark, my literary work is so novel that it needs to be registered? How do you say that? It has to be unidentifiable. No one should be able to say that this is a copy of someone other's work. There has to be some, as in startups language we say, there has to be a problem and there should be a solution by your work. If it doesn't derive that, there is no novelty in your product. So, when there is a novelty in your product, then you seek registration. The lawyers do due diligence. They see that no other term or firm or any other product by the same name is registered otherwise in the market or with the registrar of patent, trademark or copyright. And after that, the work begins. Then you have to get it registered. Now there's another problem. If you get it registered in India, how do you ensure that the same name is not being used in any other country where your trademark or copyright is unregistered? The first instant solution is that you get it registered in that country where you seek to trade in your copyright or patent or trademark. But other than that, there are various treaties of our country with other nations which safeguard your intellectual property rights. There have been various cases. There was a case in Delhi High Court. A person in some small town of Haryana was making tiles of ROCA. And he said that I have never heard of this name by any other person. But the thing was that his tiles, his trademark were registered prior in India than the other well-known trademark. So that he gave a tough fight to ROCA tiles. That was the case. So prior registration is important. As soon as you devise a product, you devise a process, you have a product in hand, you have some literary work that is novel in its nature, in its foundation, and you get it registered, then you can say that I have all the rights to use this in the market, and then you make use of it. That is how you safeguard it. So as far as the agreements are concerned, as I told you, it has to be watertight. There has to be no scope of ambiguity that can be left. Only then you can safeguard your rights in its entirety. That's all from my side for today. Any questions? Yeah.
What the agreement that is tied with the collaborative partners?
What do you call that agreement? So that agreement is called an agreement. Like an agreement for
The collaboration.
No. For as you only said, it is a collaboration agreement. Look, there are various kinds of agreement. It can be an agreement of assignment. It can be an agreement of franchisee. Collaboration agreement is a very loose term that we use in common language, but it depends on the nature of what are you trying to transfer to the other party. If you are assigning a trademark, it will be an agreement of assignment. If you are only dealing with a franchisee, then it means a franchise. Anyone else?
Let's suppose startups are mainly about creating innovative products, but most of them can be, let's say, copyright. So if you need to protect that startup, it can be copyright. You need to protect it when dealing with anything else.
By startup, do you mean a product?
Could be a product or service or an app or anything.
Of course, you are only repeating the gentleman's question. That can only be done by registering the patent or the product or the process of it.
And what if I get register for the product, confident that someone is taking the product because let's say for the website, let's say there's a, let's say,
Look, when you get a trademark registered, like Pepsi, you specify that the blue color that is there in the logo, You specify the font in which the name is written. Every specification has to be given to the detail. That is how you safeguard that it cannot be copied by. It has to be very clear. Anyone else? You have been listening very quietly. Do you have a question? Okay, so I have been able to satisfy each one of your queries and I have been very good in my lectures. Anyone else? Okay, then that's my time. Thank you very much.